Welcome to the April 16th session of Commercial Legislation 2. Today, we examine the legal framework governing international treaties. Mexico operates an extensive global trade footprint, wiring the domestic economy to 50 different countries through 14 distinct free trade agreements. These connections carry physical weight, dictating the flow of goods across shipping ports and the reduction of tariffs on imported electronics. Diplomatic handshakes and political goodwill do not define these commercial relationships. They are rigid, technical legal instruments governed by international law. Comprehending international commerce requires dissecting the anatomy of a treaty, the World Trade Organization rules that dictate it, and the mechanisms of the Mexican Constitution that enforce it. Analyzing this legal scaffolding clarifies how international trade physically alters domestic markets. The 1969 Vienna Convention defines a treaty as a written agreement between subjects of international law, primarily states or international organizations. The legal validity of this instrument is independent of its specific title, whether it is labeled an agreement, a protocol, a charter, or a convention. The binding nature remains the same. A treaty's power comes from surviving a strict four-phase procedural process. The first phase is negotiation, where state representatives debate and draft the initial text to establish core commercial or political objectives. Next is adoption and authentication under Article 10 of the Vienna Convention. The negotiated text is locked in as definitive and unalterable, often validated through a signature ad referendum. The third phase is the provision of consent. This is the moment the state officially agrees to be bound by the text, which requires domestic legislative approval, such as ratification by the Mexican Senate. Finally, the deposit phase centralizes and records the formal instruments. This mechanism is crucial for managing complex multilateral treaties with dozens of signing parties. A treaty transforms from a draft document into a binding obligation only after systematically clearing these four procedural hurdles. Once a trade treaty is established, specific legal rules govern the exchange of goods across borders. Under the World Trade Organization framework, the multilateral trading system is built on systemic non-discrimination. This is the first structural pillar, the Most Favored Nation Principle, or MNF. The rule requires that any advantage or privilege granted to one country's product must be immediately and unconditionally granted to all similar products from other contracting parties. This prevents a state from playing favorites at the border. If a country lowers a barrier for one trade partner, it automatically lowers that same barrier for all other partners in the agreement. While NMF handles equality at the border, a second rule applies once goods clear customs and enter the domestic market. This is the second pillar, the National Treatment Principle, or TN. This principle dictates that imported foreign goods cannot be subjected to higher internal taxes or stricter regulations than similar domestic products. This hinges on the concept of similar products. Equivalent goods must face equivalent rules on the factory floor and the store shelf, regardless of where they were made. These non-discrimination principles act horizontally across various frameworks, applying to tariffs, services, and intellectual property. Together, Most Favored Nation and national treatment dismantle protectionism and allow expansive free trade agreements to function. This shifts the focus to domestic application. How does the Mexican legal system absorb and enforce these international rules? Article 133 of the Mexican Constitution dictates that ratified treaties are elevated to the status of supreme law of the Union. Because treaties sit at this federal level, their creation must respect the constitutional separation of powers established in Article 49. The executive acts as an irregular legislator during negotiations, following procedures analogous to domestic law creation. This creates a jurisdictional paradox. Treaties sit directly below the Constitution, but an international obligation might contradict the Constitution itself. The resolution involved a binding international counterweight, Article 27 of the Vienna Convention, and the principle of pacta sunt servanda. Agreements must be kept. Under Article 27, a sovereign state cannot invoke its own internal law as justification for failing to perform a treaty obligation. To function correctly, the executive must negotiate treaties that align with existing Mexican positive law, ensuring no conflict between the Constitution and international commitments. A valid treaty balances supreme domestic law with uncompromising international obligations. Looking back at Mexico's global trade footprint, we see a network defined by these exact parameters. Every connection line represents a ratified text enforcing the principles of non-discrimination. These agreements function as highly engineered bridges between two distinct legal realms. The rigorous formation phases ensure the state fully consents to the strict rules of the World Trade Organization. The final result is the synchronization of sovereign economies. Via Article 133, these exact international mechanisms become domestic law, providing the legal predictability required for massive cross-border business. International commerce is the successful harmonization of sovereign constitutional law with global legal architecture.